link between the two. Does it have to be linked to a particular proceeding? Because at the time when an investigation might be in the offing, I mean, I think some of our prior cases have required that link to be between a particular investigation. So you could threaten a witness and say, don't report this to the authorities. But that could be state authorities, it could be federal authorities, there could be overlapping jurisdictional authority. So do you think it has to be close enough to an investigation for the defendant to suspect that state authorities might bring a particular investigation as opposed to the feds?
I think it wouldn't matter which type of offense it would be if you were specifically trying to prevent a witness from going to either state or federal authorities about your criminal conduct, that is still a conceivable. You're still interfering with the wheels of justice even though you don't know whether they're state or federal at that point.
Okay, let me ask you a different question then. This goes back to Justice Sotomayor's point about you using obstruction of justice in a dictionary definition rather than looking at the elements of an offense. For perjury and bribery of a witness, I assume that you would agree under the categorical approach we would be looking to generic definitions of perjury and generic definitions of bribery of a witness?
I think you could also look to the federal statutes that criminalize those crimes. You would look to state statutes as well. In a case like Esquivel-Quintana, where the court was looking at sexual abuse of a minor, it recognized that this may be a family of offenses, and it said that statutory rape is just one part of the category that's covered by sexual abuse of a minor. Here, we think it's clear
but
that—
you wouldn't necessarily start— I guess what I'm getting at is it seems like there are clusters here. You have obstruction of justice, you have perjury, subornation of perjury, bribery of a witness, and it feels a little bit odd to be relying primarily on the dictionary definition, which is up at the highest level of generality for the first one, but using kind of a more traditional approach for the others in the statute.
We're not running away from the statutes. We think that they support us. Our main contention about the statutes is that 1503 isn't the only obstruction of justice offense at the federal level.
And last question then, what does relating to do? What is an offense relating to bribery of a witness or relating to perjury?
We think there it also expands the category a little bit. The Ninth Circuit in the Yim case held that relating to perjury extends a little bit further, maybe, than the elements of the offense.
What do you mean?
It held there that a federal perjury provision didn't necessarily— the short answer is yes. We think that relating to adds to both obstruction of justice and the clauses that follow.